the tenant vacated the premises and delivered it to the landlord a couple weeks ago. So I don't know that their appeal isn't moot at this point. So I'm not sure what the basis
well, I don't know the basis of the appeal, but even though the defendant has vacated the property, they still can perfect an appeal, and for the reason I have no idea. Do you wish to proceed with the appeal?
Yes.
On what basis? If you vacate?
Wrongful eviction on the spot.
Oh, okay, yeah, so I'm saying.
But so
Even though
actually, we didn't obtain a writ of possession, and so they left after we gave notice that we're contesting the affidavit of inability to pay, so they voluntarily
vacated the property, but they don't give up the right to file an appeal on the basis of a wrongful eviction. Should they prevail at the appeals court level, then they would have to be made whole.
By vacating, they're not able. They basically waived their right because we didn't obtain a writ of possession. So the only thing that's in the judgment was for court costs. And so from my perspective, assuming that we waive court costs, then there is no basis for the appeal moving forward. If they have a separate action in small claims before this court on the basis for the eviction and they filed before we filed this eviction action. But I don't know if the judgment for possession is appealable at this point since they voluntarily moved out.
I filed the appeal after the trial on August 22nd. Therefore, I was still in the property. So I filed the appeal against the I filed the appeal after the trial. Okay, so I moved out the first. But my issue, the plaintiff's issue, he's bringing forth to contest my property holder, which he said he filed with the court, but I have not received a file stamp document for the court. And furthermore, he filed, he forwarded an email, which on August the 28th, which exceeds the 5 days, it wouldn't be contested. So yes, I'm still going to proceed with the appeal. And
but the court is of your opinion that the appeal can move forward.
Okay.
Okay.
So, Your Honor, the first basis for contesting the affidavit is that the tenant is a limited liability company that's formed in the state of Texas. So the tenant is Businesswomen LLC. Businesswomen LLC is not a person that's able to file an affidavit of inability to pay. That's for individuals based on the language in the affidavit. I mean, it's asking for date of birth and other information. And so the tenant, the defendant, Businesswomen LLC, have to post a bond or deposit money into the court because they rely on that. If a business does not have the ability to pay its obligations as it becomes due, then that business is not entitled to the affidavit of inability to pay. It's a company that can't meet its obligations. There's two defendants, obviously. There's Businesswoman LLC and there's Jeanette Johnson and the business. But the only tenant was Businesswoman LLC. And so the first point is that Businesswoman LLC, the defendant company, has to post bond or deposit money with the court if it wants to perfect its appeal.
you brought the suit against Businesswoman LLC and Jeanette Johnson. The eviction suit is against Jeanette Johnson, who got to stand before you pay person. Therefore, the appeal is approved. Because you brought the suit against me.
So there's two defendants, and so for both defendants to perfect their appeal,
We're one and the same.
Ma'am, let him finish, please.
there's presumption in Texas that a company being formed is a separate, distinct legal entity. And so as a limited liability company, businesswoman LLC has to post bond or deposit money to court. So I believe that the bond amount was set at $1,000 to expect the appeal. So for businesswoman LLC, that company cannot rely on the affidavit for the ability to pay. Realizing also that at county court on the appeal, businesswoman can actually have an attorney. So for effective appeal, it's going to need to post bond and then also hire an attorney.
What I'm looking for is the petition.
You want to have a copy if you'd like to?
Yeah, let me see, but I'm having trouble going through this. Okay. Ma'am, this was filed against Business Women LLC.
And it also has my name.
That's you're the owner, because Business Women, that's an entity. It's not a human. And
You
so-
should have brought the eviction suit against Jeanette Johnson.
Well, ma'am,
Since he's claiming now that it's two different defendants.
the
This is after.
ma'am, that the responses to the affidavit that you filed, affidavit of inability, that's what it's basically going down. It's I think it'd be the first time I've heard that legal argument, but I think it's a valid point.
I object to that, that's not a valid point. Here, the petition says.
Well, that's my determination.
The eviction says.
You may not agree with it. See, you're gonna try to talk over me, I'm gonna talk real loud. Okay? So,
May I say something else?
not right now. Could I get you to write the order for the court on the basis of Business Women LLC?
Yes, Your Honor.
Okay. So, did you have anything else you want to say?
Yes, I have something else I want to say. I have not received a file, he has not filed this with the court. First of all, when it exceeds the 5 days, he's trying to make a legal argument that is,
What
against the
exceeds
company
5 days?
or myself. 5 days to contest my appeal. He contests this, send it in an email on the 6th day.
So
Therefore-
he served a copy of the filing.
You did e-serve it to me, you can't e-serve,
No, he
a
filed.
JD court.
We served you via e-service and then filed the copy with the court.
I need a copy of that, because I don't have it. I don't see a file stamp on this. And like I said, you did it after the 6th day, you have 5 days to contest any appeal. You did it on the 6th day.
Actually, on the very same day that we received notice that you had filed an affidavit with the inability to pay, that's when we filed our notice of contest.
Which
Excuse me,
in
1
this
minute.
document.